Hey guys, welcome to another episode of Suits and Boots Legal Talk. Today, we're talking about contracts. If you're buying real property, you need one. Hey guys, so today we're talking about contracts for the purchase of real property. It's just me again today, so you're stuck with just listening to my voice and hopefully you don't fall asleep. And we'll try to keep this entertaining as much as possible, but some of the stuff we're going through is going to be a little drudgery maybe, but you guys hang in there. And because this is really important information, if you're thinking about buying a house, if you've bought a house, you've probably seen one of these things before. It's a lot of pages, it's a lot of detail, and it's something that you need to know about. One of the things to keep in mind in North Carolina, if you're buying real property, your purchase agreement has to be in writing. So if you guys just, we all like to think about the handshake deal, and wouldn't it be great if we could all just shake hands and agree to do something, and that's what happens? But we know better. Today, in this day and age, it just doesn't work that way anymore. And actually in North Carolina, it's the law that if you want an enforceable contract for the buying or selling of real estate, it has to be in writing and it has to be signed. A lot of people think it has to be notarized, but it actually does not. But it does have to be signed. No notary required. Now, what does that writing have to be? Well, it can be as simple as a text message back and forth between the two parties. That can evidence a writing. It can be just written down on a napkin. That can work. However, those two ideas are not ideal. So, what happens whenever you do want to buy a contract? Well, the North Carolina Bar Association and the Association of Real Estate Agents has put together a document that is really comprehensive and really helpful whenever you're purchasing real property. It's the document, if you use a real estate agent, it's the document that your agent is going to use. And it's right here today. We're going to look over it. So this is what's called the Standard Form 2T contract. So this contract is the form that was developed by the North Carolina Bar Association and the Association of Realtors. So this is what everybody uses whenever you're buying or selling real property. Today we're going to just go through some of the points, the high points of this document, and just show you some of the things that you need to be looking at if you are thinking about buying property. And when you sign this thing, what does it say and what does it mean? So let's look at it today. All right, so the first thing you're going to see is this first section here, seller, buyer, terms and definitions. So these things seem like they would be really simple, right? The seller and the buyer, who are those people? What do you put in there? But sometimes those can be really complicated, especially if you're looking at the seller. So the seller, you always have to have your spouses. So a lot of times people think, well, I'm selling my property. This was left to be my mom or dad. I don't need my wife's name on there. But guess what? You actually do need your spouse's name on there. Anytime real property is being sold, unless there is a free trader agreement or some other agreement between the husband and wife or the spouse, there needs to be a spouse signature on there. They do need to sign. Same thing for heirs. So you inherited this property. You got to get all of the heirs to sign this contract, all the heirs and their spouses. So make sure when you're looking at the seller, make sure we've got all the signers on there that we need. Second, the buyer. Who's actually going to be buying this property? Is it going to be an individual? Is it going to be a business? Do we know? A lot of times in the commercial world, when we have someone buying property, they might want to sign the contract in their personal name because they don't have the entity created yet that they want to title the property in. So maybe we put John Smith's name down here, but the actual buyer is going to end up being Smith Land Development, LLC, or something like that. So we can always make this thing assignable. So maybe we put John Smith or assigns, so where we can assign this contract to the new buyer of the property. So maybe eventually it's going to be somebody besides John Smith. So the buyer's name is not nearly as important as the seller's. We want to make sure to get those sellers in there and get it right. So this contract is updated periodically. You'll notice that this is the 724 version. So this contract, this version came out this past July. Some things that have been added in the last few versions are these things right here that say, will the property include a manufactured home? Manufactured homes have some sort of special things that we have to do because, hey, they can be hooked up to the truck and pulled away, and we want to make sure that doesn't happen. Off-site septic lot, boat slip, garage, parking space, or something like that. We've got terms in there for that. The next stuff down here is all of the property information. So all of these blocks right here, that's all the property information. So the address, the legal description, all of those things in there. The address is great. We want to get that in there. The city, obviously, North Carolina, county. Right down here, though, we want to get as much information in these blocks as we possibly can. This will help the attorney to identify the property that you're actually buying. So is there a plat? Has it been surveyed, and is that survey recorded? That would be the plat. What is the PIN number, the tax identification number for the property with the county? And then this deed book and page. So when the Register of Deeds records a deed, how do they index it? So they index it in a book, and they'll have different book numbers, and then it'll be on a certain page in that book, and that'll give you the exact. So when you go book and page, you can go online and enter those two numbers and go directly to that deed. Now, what some people would say is the most important part, the purchase price. So how much money is being exchanged to purchase the property? Well, one of the things we look in here and we see this is where going to be the total purchase price in this blank right here. Under that, we have the due diligence fee, and due diligence is what the buyer will pay directly to the seller, typically non-refundable. So when you pay that due diligence fee, you're not going to get that back, even if you terminate the contract. In the case of a seller breach, you may be able to get that money back. Then we have earnest money deposit. So the earnest money deposit is paid to an escrow agent. We'll go over that here in just a moment, but the earnest money is paid to an escrow agent. And just is the way for the buyer to let the seller know, hey, I'm really interested in this property. I'm going forward. The earnest money is refundable under certain circumstances. And we'll go over some of those things here in just a moment. Additional earnest money. So, maybe you paid earnest money and then something happens. You need to extend due diligence. Or you need to extend the contract. So you might pay some additional earnest money, and that would be written in right there. Assumption, this is something that's really rare. You don't see this a whole lot, but sometimes when folks are buying property, they may assume a deed of trust or a mortgage that's on the property. So let's say you're selling the property for $200,000 and you still owe $100,000 on the property to Bank of America. Well, the buyer can come in some circumstances. Like I say, this is very rare. In some circumstances, the buyer can come in and take over that $100,000 loan and then pay you the other $100,000. So they pay you $100,000 and then they take over your loan. So that's what that would be. And then seller financing. This is something that we're seeing more and more of with interest rates being high. We just heard this past week that interest rates are coming down. We'll see what actually happens with that. But in the meantime, a lot of folks are using seller financing because sellers are often, if the bank's going to get 8%, a lot of sellers are like, you know what, I could use 8% on my money. So they'll do some type of seller financing, and that would be entered in right there. And then building deposit if you're buying some kind of new construction property. And then down here at the bottom is the balance. So this is how much of the purchase price is actually going to be paid at closing. So this is the balance of the money that has to be brought. So there's page 1. Now, as we go on through, you'll notice page 1 of 17. This thing is really, really detailed. So this contract goes through everything that you might need to consider when buying or selling a property. So here's some definitions for us. The earnest money deposit, that's that deposit we talked about. It's usually held with an escrow agent, and that's the next paragraph down. The escrow agent, sometimes it's the closing attorney, sometimes it's the real estate agent, but that's who holds the earnest money. As you go down, you'll see the effective date. So the effective date is the date that this contract is signed. A lot of times the contract will have terms related to the effective date. So sometimes it'll say, the due diligence period is from the effective date through the date that is 30 days later. So that's just saying if this contract is signed on September the 14th, it's going to be good through October the 14th or 13th. Whatever day is 30 days after that is the due diligence period. And then they may say, and then another 14 days to closing. So it can be really important when that effective date is, and that's the last date that the last party signs the agreement. So if the buyer signs today and the seller signs tomorrow, tomorrow is the effective date. Due diligence. So due diligence is the buyer's opportunity to investigate the property. So that due diligence period often may be 2 weeks, 3 weeks, 4 weeks. It varies depending on the contract. Some commercial contracts will have due diligence periods as long as a year to a year and a half. So the due diligence period will go out and give the buyer the time to do inspections, to check out the property, make sure this is the property that I want to buy. And this is really, really important, guys. So the due diligence period gives you the opportunity to inspect the property. If for some reason during that due diligence period, or the contract's going to say if for no reason at all, you decide, okay, you know what? This is not the property that I want to buy. The buyer has the right during that due diligence period to terminate the contract. If the buyer terminates during that due diligence period, the earnest money that has been paid will be refunded to the buyer. Any due diligence paid will not be refunded. So if you pay $1,000 in due diligence and $1,000 in earnest money, if the buyer terminates during that due diligence period, they'll get the $1,000 in earnest money back. The $1,000 in due diligence money is gone. So keep that in mind. This due diligence period is really, really important. And that's what the next paragraph talks about, is the due diligence fee. So the due diligence fee that you've paid is non-refundable except in the case of seller breach. So if the seller breaches this agreement in some way, then the due diligence can be repaid. And then we have the due diligence period, the definition of that. So it's going to extend through 5 p.m. on whatever date, or this many days after the effective date. So that's what we were just talking about. Settlement is when we all sit down at the closing table. That's when you guys come to my office, we sit down and we sign all the documents. And then the settlement date is the date that will occur on. Sometimes that's listed as an actual date. Sometimes it's listed as maybe 14 days after the close of due diligence or something like that. But something will be filled in there to say this is when we're all going to meet at the attorney's office to close this thing. Now, everybody thinks that settlement and closing are the same thing, and most of the time they're pretty close. Actually, the closing, so the settlement is when we sit down and actually sign all the documents. The closing here is defined as when the completion of a satisfactory title update to the property following settlement. So the closing attorney's authorization to disperse all necessary funds, the recording of the deed, and all of those things have to go into the actual closing. So the property doesn't close until the deed is recorded and the attorney disperses the funds. So when we sit down at the table, we're actually doing what's called a settlement. And then whenever we disperse the funds, that is our closing. And the reason it's called a closing, interestingly, is that it's the closing of escrow. So it's basically me, I've taken in as the closing attorney, I've taken in all of these funds to close this transaction, to settle this transaction. And we open what's called an escrow account. So an escrow where we hold buyer money, seller money, or any money that's maybe been paid to us. At closing, we close that escrow account. So we empty it out. We disperse everybody's funds. Whoever gets any money out of this deal, that account gets closed. And that's why it's called closing. Little useless knowledge for you today. So as we go on through the document, you'll see special assessments, any charges against the property by a governmental authority or something like that have to be disclosed and paid. Fixtures and exclusions. So we've talked in here just a little bit about fixtures and those kind of things. Look, you'll see these, as you read through these contracts, you'll see these big warnings all over the place. And that's because the people who are drafting this contract, they're sitting in Raleigh or somewhere else. And the folks who are typically going over it are not attorneys, and they're not folks who would normally be looking at 17 or 18-page contracts. So here you'll see the parties should not assume that any item will or will not be included in the sale based on an oral or written statement or understanding that is not part of this contract. So if there's something there in the home that you want to convey, make sure, or that you want to get in the purchase or that you want to sell in the purchase, make sure it's included in this agreement. So the curtains, the furniture, the washer and dryer, any of those things that you expect to convey, make sure, or that you expect to get with the property, make sure it's listed here. Here are some specified items on the next page of things that will convey unless otherwise agreed. So stoves, ranges, ovens, those kind of things, antennas, satellite dishes, and receivers, basketball goals, play equipment, things that are permanently attached. So think about things that are permanently attached to the property. Those things will be things that go with the property. Some washers and dryers, they can be unscrewed very quickly and taken, so those things do not convey. If you want the washer and dryer, you need to put that in here. If you want the refrigerator to go with the property, you need to make sure that's in here. Here's something that we don't think about a whole lot, but your devices. So if you've got doorbell cameras, video doorbell cameras, any kind of security system, any kind of paired device with something that's going to stay on the property. A lot of times your thermostats now for your heating and air system will be Wi-Fi. And so you may need to unpair those things from your phone. And if you do have them paired with your phone, you need to unpair any of those devices and reset those to factory defaults so that the new owner coming in can hook up to those things. And notice that anything required here shall survive closing. That means just because you've closed on the property and everybody's got their money and everybody's walked away, if you haven't done this as a seller, it's something you're going to have to do. So then items leased or not owned. So things like propane tanks, things like that may be on the property that, hey, the seller says, hey, yeah, I know there's a propane tank here, but I don't own that. That belongs to, whoever the propane company is. And then maybe you want to list some items that, hey, these are not going to convey. And I've been using that word convey quite a bit. And all that means is it's just going to go from the seller to the buyer. So it's something that's included in the sale of the property. Anything that you don't want to be included. So seller, maybe that range that's in the kitchen is really, really important to you. You better put something in here right now if you don't want that thing to convey. So if you want to exclude something, you need to put it in here. It all needs to be up front. Personal property. So these are things that are not fixtures to the property, but may convey. So you may be able to transfer some personal property. We've done a few closings where we did a closing a few years ago that was on a junkyard. And there was all of these salvage vehicles there on the salvage yard, and those salvage vehicles conveyed with the property. So we list, hey, all of the salvage vehicles on the property, they go with the property as well. So that's something that you would have to list here, and that's a little bit of a weird circumstance, but that's something that we've seen before. So we've talked about due diligence. And we've got this buyer's due diligence process here. So look at this box here. Buyer is strongly encouraged to conduct due diligence during the due diligence period. This is over and over again. Prior to the expiration of the due diligence period, you can terminate this contract for any reason or no reason, and the seller is not obligated to grant an extension of the due diligence period. So that's really important, guys. Make sure if you're under contract, get that due diligence conducted because it's the time period that you have to back out of the deal if you're the buyer. So buyer can obtain a loan if they want to. Investigation, they can do inspections. Buyer can do inspections, review documents, insurance, appraisal, survey. These are just some of the things that the buyer may want to do before the close of due diligence to check out, hey, is this really the property for me? So unless otherwise provided, contract is not conditioned upon the sale or lease of other property. So sometimes a buyer may have a home and they want to sell that home and buy something else, and they can get under contract on a new property and say, hey, I'm only going to close this thing if I can sell the property that I have now. So if that's the case, then the buyer needs to make sure and tell their real estate agent, hey, this is conditioned upon the sale or lease of other property, and there's things that we need to put into this contract to do that. So when the buyer is doing any kind of due diligence, they have an obligation to repair any damage they've done. Most notably, this is likely going to come up where you have a buyer that's looking at buying a lot to build a home. Maybe they go in and they want to do perk testing, and so they come in and they have to dig all these holes to check the ground to make sure it's going to be suitable for a septic system. So that's what this would be. You need to fill those holes back in, make sure you don't leave any open holes on the property. Buyer will indemnify the seller. So if somebody gets hurt in that due diligence process, the buyer's going to be responsible for that and make sure that the seller is covered unless the seller has done something to contribute to that damage. Buyer's right to terminate, so the buyer has the right to terminate. This paragraph right here, 4H, it's in big, bold, all caps. Closing, if we close, closing shall constitute acceptance of the property in its then existing condition unless provision is otherwise made in writing. What does that mean for you buyers? That means if you buy this property and if you close on this property, you own it. However, whatever condition it's in, you own it, it's yours. That's why it's so important to do that due diligence process. And it's so important to negotiate any repairs, anything that you think you might see, like, hey, that looks like this basement has been wet before. Well, you might want to look into that and see, does this basement leak? Anything like the septic system, any kind of inspections on wells, those kind of things. Get that done before closing. If you don't, after closing, it's yours. You own it. So just make sure to think about those things when you're going through that due diligence process. Buyer representation. So the buyer has to say, we've got enough funds to close this thing, or we're getting a mortgage to close it. Buyer does not have to sell other property, or does have to sell other property. That's that contingent aspect that we were talking about earlier. And then buyer, to the best of buyer knowledge, there are no circumstances that would prevent them from buying this property. So the buyer is also going to get some disclosures about homeowners association. Is the property in an owners association? Mineral, gas, oil, and gas rights mandatory disclosure statement. So that rarely ever comes into effect here in North Carolina because we don't normally sever mineral, oil, and gas rights from property here in North Carolina. The buyer obligations, the buyer shall take subject to all special assessments that may be approved following settlement. Responsibility for certain costs. Here are some of the costs that the buyer is going to be responsible for. You see these things listed here. There's authorization to disclose information. So the buyer authorizes the buyer's lenders, real estate agents, closing attorney to release information. So all these people need to be able to talk to each other in order to get this closing done. Seller representation. So the seller's going to say, hey, these are things that are true about what I know of the property. So they're going to talk about their ownership. Was it built prior to 1978 so that it may have lead-based paint in it? And then here's a lead-based paint disclosure. So just keep that in mind. If it's built prior to 1978, you have to disclose that because it probably has some lead-based paint in it unless it's been gutted at some point. Homeowners associations and dues. So if it's in a homeowners association where there's dues paid, you have to disclose that information, who the association is, that kind of thing. Fuel tanks. So if there's a buried fuel tank, you need to disclose that information. Is it in use? What's the status of it? Is it leased? What's going on with it? Is there more than one tank? And is it included in the sale? Those kind of things. So make sure to disclose any information about fuel tanks that might be on the property. Is the property leased? So if it's a property that you're selling and you've been renting this property to someone, is there a current lease? And you have to disclose the terms of that lease. Seller obligations. So the seller will have to show evidence of title. They'll have to provide payoffs for any deeds of trust that they have. So those things can be paid off and canceled of record. And they'll have to sign this thing called a non-foreign status. What that means is if someone is selling property and they live in another country, then the IRS will require the buyer to withhold 15% of the proceeds from the seller in order to pay the seller's income taxes from that. That'll be sent directly to the IRS. The way you avoid that is for the seller to sign what's called a non-foreign status affidavit, basically saying, hey, I'm a resident of the United States. I'm going to take care of paying my taxes. The United States has jurisdiction over me. What the IRS is concerned about, Uncle Sam's going to get their money, is that, hey, we're going to wire this money to who knows where, and they're never going to be able to get the taxes from the for the capital gains that you may have gained on the property. So a lot of times you'll have to sign those non-foreign status affidavits just saying we are residents of the United States. Seller also has to give authorization to disclose information. The attorney doing the closing has to be able to talk to the seller's lender and those type of things to get that payoff information. Seller has to give access to the property. So the buyer's going to need to get in there to do the due diligence to make sure the property is what they want to buy, and the seller needs to give that access to the buyer. The seller will remove the property before the possession is given to the buyer, so they got to remove any kind of personal property that's left. Maybe it's not a junkyard, but maybe it looks like a junkyard, and the seller has several vehicles that haven't ran in years. Before closing, those things need to be removed from the property. Affidavit and indemnification agreement. So one thing in North Carolina that you guys need to know is when you are buying property, it comes subject to any liens that may be on that property. There are liens in North Carolina that are not recorded, and that can be a real tricky thing for people. So a mechanics or materialman's lien is automatically given to anyone who's worked on the property within the last 120 days. So let's say the seller has had the heating and air system checked out prior to putting the house on the market. If that heating and air company comes out and works on the heating and air system, they automatically get a lien on the property for whatever the amount of the value of the work they've done. That lien is good for 120 days without anything filed of record. So what we do here in the contract is this section E here says that the seller will sign an affidavit and indemnification agreement. This says, if there are any liens like that on the property, the seller will pay those if they come up, or they have paid them. They're either saying there aren't any liens for mechanics and materialman's liens, or if there are, the seller will take care of it. So they're going to pay those liens for any of that kind of work done. So designation of lien agent, that's all about those are those same liens where there's a certain amount of money. I think it's $100,000. I'm not exactly sure. If the amount of work done to the property is over that amount, there's a lien agent that has to be appointed to accept those liens. The seller has to convey good title through a general warranty deed. So they have to provide good title to make sure it's marketable. Governmental compliance. This one is one that has really popped up in the last year. I've seen a couple of these. So we're in Section 8, subsection H of the contract. So this says it is a condition of this contract that the property be conveyed free of any material violation of law, ordinance, permit, or government regulation. So what that means is that if for some reason the home built on the property is within the setback of the government, the zoning regulations. So setback means that your buildings on the property can't be within so many feet of the property line. It maybe the septic system is out of compliance with the government regulations or whatever. If the zoning's wrong, or maybe your house is built too close to Lake Norman or too close to Lake Hickory or one of the lakes, maybe it's in that floodplain of that lake and you didn't get approval for that prior to building it. If that happens, then this contract, and you don't disclose it, if the seller doesn't disclose it, then that is a condition of the contract. And if the seller does not cure the violation prior to closing, then the buyer may choose to accept the violation and proceed to settlement, or terminate the contract and receive a refund of the earnest money and the due diligence fee. So if this is a problem, if there is some part of the property that doesn't comply with government regulations, it could lead to a seller breach of this section of the contract, and the buyer can receive their earnest money and due diligence back. So the seller will pay for preparation of a deed, and that'll be the seller closing costs. So they pay for the preparation of the deed, the excise taxes in North Carolina. That's $2 per thousand of the sale price, and that's paid to the county wherever the property is being sold. And any deferred, discounted, or rollback taxes. So if your property is in some type of agriculture or forestry use program, there will be rollback taxes when you sell that, and you will have to pay those. So if you're in one of those programs, make sure to talk to your local tax office, and they'll tell you, hey, here's how much your rollback taxes are going to be. The sellers pay those unless you guys agree otherwise. The seller can agree to pay some buyer expenses. So sometimes we see the sellers agree to pay some of the buyer's closing closing costs in order to sweeten the deal. And we've heard Matt in here. If you guys remember, he was here. It's been a few episodes ago talking about how the buyer can really get a big benefit from maybe not reducing the purchase price, but getting the seller to pay toward a buy down rate. So buy that interest rate down on the loan. So that's where that information would be entered. Homeowners Association and charges late listing penalties. So if the property has been improved, that's what this late listing penalties is all about. Maybe you built a barn on the property and you didn't tell the tax office about it. Well, the tax office is going to call that a late listing, and they're going to charge you a penalty for that. So the seller pays those things. And at closing, whenever you come in, you'll see a form that we have you sign that says, hey, you're responsible for these things. If something comes back and the tax office says, hey, we've got a late listing penalty on here, that's coming back to the seller. So the seller's breach of contract, we're going to get into that here in a little bit. Charges by homeowners associations. So here are the things the seller's going to pay. Here are the things the buyer's going to pay. Those are all pretty specific. Prorations and adjustments. So we always prorate the taxes on real property. What that means is that if the taxes, so let's say you're closing right in the middle of the year, June 1st. So from January 1st through June 1st, the seller is going to pay whatever the property taxes are for that year. They're going to pay their portion. So we're going to take that. If the property taxes are $1,000, we're going to take $1,000 divided by 365 and then multiply the number of days the seller owned it and then the number of days that the buyer is going to own it. So the buyer pays their portion, seller pays their portion. This gets a little tricky when the tax bills haven't come out. So here in North Carolina, the tax bills are paid in arrears. What does that mean? That just means that the taxes for this year are going to be paid after this year's over. So it gets a little tricky. The tax bills usually come out in sometime in August, September. Usually by the end of August, we have those tax bills. And what we'll do then is if the tax bill is out for 2024 in August 2024, then we'll know, okay, this is how much the taxes are for the property. We'll go ahead and pay that bill at closing. So the buyer contributes their portion, seller contributes their portion, and the bill gets paid. If that bill is not out yet, then we have to look at last year's bill and figure out how much is this year's bill going to be. Usually they're really close to the same, and we'll have you sign something at closing saying, hey, we're guessing at this because we don't have the bills out this year, but we're going to get it pretty close. So what'll happen then is the seller will give a credit to the buyer for the amount of their portion of the bill. So if the bill is $1,000 and the seller's half of that is $500, or seller's piece of that, it might not be half, but a piece of that is maybe it's only $250 because we're closing early in the year, and the buyer's going to pay the rest of that $750. What'll happen is the seller will give the buyer a credit for that $250 on the settlement statement, and then the buyer will pay the full bill when it comes out. So the seller's paid their portion at closing, and then whenever the bill comes out, if it's $1,000, the buyer will just pay that full $1,000 because they've already gotten the $250 from the seller, but they can't do it, they can't pay it until the bill comes out. So that's the way that works, and it can be a little tricky to understand whenever you see that at closing. So as we go on, we'll see there's a provision here for a delay in settlement. So if either party delays settlement, they have 7 days from that settlement period. So there's kind of a delay, a grace period here of 7 days. So if it's supposed to close today and it doesn't get closed today, for whatever reason, whether it's the buyer's fault or seller's fault, then they'll have 7 days to correct that problem. Possession, so we can have different types of possession. Typically, buyer gets possession right as soon as it's closed, but you can do a seller possession before closing or buyer possession before closing where you let the buyer move in early, or you can allow the seller to stay after closing. Those things have different forms that we need to fill out and different ways to work that. There's all kinds of different scenarios that can come up, and so we have different addenda that may go into this contract to deal with those different scenarios that we might see. So this assignment, we talked about if this contract can be assigned, and a lot of times that's important for buyers because maybe they went under contract as Luke Martin, but hey, now I want to sell it to Martin Real Estate, or I want Martin Real Estate to end up buying it. So I may need to assign it. I'm going to have to get permission for that. I can do that by putting in the buyer block, Luke Martin, or assigns, or maybe I just go back to the seller and say, hey, we want to assign this contract and have everybody sign something saying that it's going to be assigned. Parties, survival, entire agreement. So basically this says this is the entire agreement of this is everything between the parties. There's nothing else out there. We don't have any handshake deals. Everything we've agreed to is in this document somewhere. So that's something to keep in mind. If you want to make amendments to the contract, you can, but just make sure those amendments are in writing and signed, and they need to reference this agreement. So conduct of the transaction, everybody's going to act in good faith. This is the really boring stuff that talks about how we're going to count days. You would think that it just seems intuitive. Like, hey, if you got 7 days grace period, does that include holidays? What about weekends? What about? And so everything in here is addressed. And then we have the remedies. So if you have a breach by the buyer, here are the seller's remedies. Interestingly, in these contracts, the seller's remedy is often limited to the earnest money deposit. So if the buyer has put down $1,000 in earnest money and the buyer doesn't terminate the contract before due diligence closes, the seller's entitlement to any kind of damages is usually just the earnest money. So it'd be that $1,000. The idea here is that if the buyer breaches this contract, then the seller has the property. So it's not like they're out a whole lot. Maybe they've lost some time, maybe they've lost some other things, but they still have the property and they can go and find another buyer and they can still sell the property to someone else. So if the buyer breaches the agreement, the seller's damages are really limited. It's usually limited to the amount of the earnest money that's been paid. So if there's a breach by the seller, real property in North Carolina and across the world is considered a unique asset. That means that the buyer can't go out and buy this property somewhere else. Your property seller is very unique. It's very special. And you know that, and the buyer knows that. So they've looked at houses, they've looked at properties, and they picked yours. There's no other property like yours in the world. And so if the seller decides, hey, I don't think I want to sell. We were going to do it, and now we're not going to do it. We've decided, seller's remorse. We really like our house. We really like our property. We don't want to sell it. Well, the buyer says, yeah, I really like it too. And guess what? There's no other property out there like it. So that means what's going to happen if you've signed this contract, seller, and you've agreed to sell the property, if the buyer desires to buy it, they can force your hand to sell it. So they can take you to court and a judge will rule for what's called specific performance, which is where the buyer can force a sale of the property and they will end up getting the property. Most of the time, we can work something out, we can sell it, but it gets really messy because at that point, everybody's emotions are involved and it's just not a good thing. If you don't want to sell your property, do not sign this agreement. Do not sign a contract to sell your property if you don't want to sell it. Once you sign the agreement, it's too late to back out. Just assume once that agreement is signed, the property's gone. You don't have it anymore. Now, the buyer can back out, and if you don't want to sell it, maybe you get lucky and that's what happens. But as seller, you're hooked. You're on the hook. So make sure if you don't want to sell the property, don't sign the contract. In certain circumstances, you can get attorney's fees. So if the parties are having to sue one another for some reason to get some earnest money back or get due diligence fee paid or get due diligence fee back, then the courts will oftentimes award attorney's fees for that, and that's provided for in the contract. And then we have the signature page. So one of the things to make sure on the signature page is that the sellers all sign, whether it's spouses, whoever, heirs, everybody that's on that line on the first page, you need to make sure you have a signature form on the second page. And as we said earlier, the sellers do need to sign. Guys, that's it. So this is a really, really deep document. It goes through so many things, and there's a lot of stuff that we skipped over here. But in 40 minutes, I can't imagine that you've sat and listened to this whole thing without falling asleep. But if you have, congratulations, you're winning. But one thing to keep in mind, this document goes through almost every scenario that could come up. If there's some specific question you have about selling your property or buying a property and you're like, hey, what happens in this scenario? make sure to ask your attorney. A lot of times, the real estate agents will be the ones helping you fill out this document, and they do an excellent job. And what they're dealing with here when they fill this document out are facts. So they're talking about disclosures. They're talking about representations, about things that are true about the property, about the buyer, about the seller. But if for some reason you have a question about, hey, what does this term mean? What does this mean for me? What are the consequences here if this is true or that's true? Oftentimes, the real estate agents will refer you to your closing attorney. And that's where we come in, because we interpret these contracts and we can tell you the legal consequences behind signing this or signing that or saying this or saying that. We can draft custom contracts, custom addendums to these contracts, where we can do things like we had a contract one time where there was a vault in an old bank. And the seller's like, hey, I want to remove the vault from the bank. Now, there's still going to be a room there, but I want to make sure and get that vault out of there and take that with me. We can do that. We drafted an addendum to make sure the seller was allowed to do that. So just anything you guys can think of, as long as it's legal, then we can probably help you make sure that happens. So let us know what you got going on. Hey, let us know in the comments if you have any questions, guys. Thanks so much for watching. I know this one was a long one and it was in-depth and detailed, but hopefully if you're going under contract on a home, whether you're buying or selling, this is going to be some help to you. So thanks for watching, guys. Make sure to like and subscribe. Keep up with us and we'll keep this good information coming. Thanks so much.
The information contained in this video and audio recording is general in nature and should not be relied upon in making legal decisions. Every situation is different, and you should consult with your attorney before making any legal decisions.